invited here to give the Users Council lecture. It's a fantastic audience. It's a really very engaged audience. There's a lot of very enthusiastic legal professionals here in Mauritius, and I've been thrilled to be here.
You had a Q&A this morning as well. Can you tell us a little bit about what you talked about?
That's right. It was a Q&A with a lot of the younger lawyers from the Mauritian legal community. It was Chatham House rules, so non-attributable to individuals. But we talked about quite a wide range of matters, particularly about how one develops a career in arbitration.
Percent of the shares in a party to the arbitration would clearly be unacceptable. But what if it's 10% or 0.1%? What if the company is publicly listed and this is just part of a much broader portfolio held by the arbitrator? What if the shares are held through a trust? Where exactly do you draw the line? When you're considering commercial or family or social relationships, again, one has to look at the nature and the quality of the relationship. But potentially there's a very broad network of relationships that might be relevant between the parties, employees and officers of the parties, counsel, co-arbitrators, and anyone else who might have an interest in the outcome of the dispute, such as insurers, for example. Now, some of you may be thinking, after what I've said, that it sounds as though potential conflicts arise at every turn. Well, there are some situations which I think many people would agree on as being what I might call safe, as not giving rise to conflict of interest. Personal attributes, for example, such as race and religion, do not of themselves give rise to concerns about independence and impartiality. But in a racing case in Australia, for example, one of the parties sought to challenge the 3 members of the tribunal, which consisted of 2 Australians and 1 Englishman, on the basis of their shared cultural heritage. They were all part of the British Commonwealth.
Relevant experience, and also some of the more specific details about how the process works, some of the challenges of dealing with arbitrations, some of the areas that are still a work in progress that we can improve upon. And I was also asked a few questions at the end which were bounced on me of some particular hobbies and other likes and dislikes. So it was a good, fun session, and again we got some really good questions from the audience, so I hope they enjoyed it too.
Decision makers. And against that background, it's easy to see why conflicts of interest can have a broader implication than simply the outcome of any one dispute. They have the potential to damage the legitimacy of the process of international arbitration. And the imperative to avoid conflicts of interest leading to this result can actually override other key principles in arbitration, such as party autonomy, and particularly the right of a party to select their own chosen arbitrators. But of course, conflicts aren't confined to arbitration. They're just as significant in the context of domestic court proceedings. Basic principles of due process and natural justice require that no one can be a judge in their own cause. But arbitration has particular features which arguably make conflicts of interest more likely and potentially more damaging when they do arise. For example, the point I've put up here, judges are usually regulated and subject to discipline and oversight as part of a formal judicial system. But in most arbitration systems, any natural person can be chosen to act as an arbitrator. They may not even be required to hold any legal qualifications or otherwise to meet any objective standard of suitability or experience. One would hope if you have an arbitrator appointed by an institution or confirmed by an institution, then some form of standard would usually be required. But in principle, a party can nominate whom they like as an arbitrator, and there's no independent verification or regulation.
j'espérais qu'ils vont aussi bénéficier par ça, surtout. Il y a un nouveau sujet, il y a un avocat who is engaged into arbitrations. Enfin, il y a beaucoup de pays dans l'Afrique, mais c'est pas assez comme si lancer dans ce domaine-là, on espérait, il va arriver.